Good morning. My name is Muiruri Peter. I'll be a presiding judge today. I hope to have an amazing session with you guys. With me, my court judge. She will introduce.
Good morning. My name is Nerea Kinyi. I'll be the presiding judge today. I hope you guys have a wonderful time and give out good submissions. Thank you.
The applicants.
Honorable members of the bench, appearing before you is first counsel for the applicants. My name is Mugo Blessing Wanjiko. I'll be addressing the first and second issue, while my co-counsel, Whitney Nyarangi, will be addressing the third and the fourth issue. We'll be using 12 minutes of the allocated time to adduce our arguments and set aside 1 minute for rebuttals. With the permission of this court, we seek to proceed. Thank you. The appellants approach this honorable court with assertions based on both the law and evidence to back the claim that this honorable court has the requisite jurisdiction to hear and determine the matter currently before it. We advance the following arguments in support of this claim. First, this court meets the jurisdictional threshold set out under Article 163(4)(a) of the Constitution of Kenya 2010. We submit that this court has jurisdiction to entertain the appeal as it arises from the High Court and the Court of Appeal, and it involves matters constitutional interpretation and application. We rely on the Constitution as interpreted together with Section 15A of the Supreme Court Act, which grants this Constitution jurisdiction to hear appeals arising from the High Court and the Court of Appeal in matters involving constitutional interpretation and application. My lord and lady, these principles were pronounced in the case of Lawrence Ndutu and 6,000 others versus Kenya Breweries and another case of 2012. The Supreme Court held that not all cases qualify to be heard in the Supreme Court, only those arising from matters involving interpretation and application of the Constitution. This court further emphasized in the case of Gitaru Peter Munyao versus Dixon Mwendwa Kithinji, case of 2014, that at the very least, where the Constitution cannot be identified as having formed the gist of course at the Court of Appeal, an appellant should at least demonstrate that the appellate court's reasoning and conclusion, which led to the determination of these matters, took a constitutional trajectory. My lord and lady, move with me to paragraph 6 and 9 of the compromise. With analyzing the decisions of the High Court and the Court of Appeal, we submit that the issues on appeal took a constitutional trajectory. Move with me to paragraph 2 of the fact sheet. For instance, both courts sought to determine whether the collection of GPA and DNA of the people of Kenya through the implementation of NIIMS violated the constitutional rights under Article 31 of the Constitution of Kenya. Additionally, throughout the proceedings, both courts seemed to rely on the interpretation and application of the Constitution in the determination of these issues.
Counsel,
my lady.
Can you state the full meaning of NIIMS? And what article have you?
I've used Article 31 of the Constitution of Kenya.
Is it absolute?
Thank you, my lady. Article 31 is not absolute. It is subject to. It is not absolute, and the rights can be limited. The appellants have the requisite locus standi. Article 258(1) of the Constitution of Kenya allows any person to institute proceedings where the Constitution has been violated. My lord and lady, Digital Watch Rights Network and Kenya Human Rights Advocates qualify as they advocate for constitutional accountability, acting on behalf of affected citizens. My lord and lady, in the case of Katiba Institute and another versus Attorney General and another, case of 2020, the court affirmed that organizations can challenge unconstitutionality of...
Which court? Which court?
This court. This court. this court affirmed that organizations can challenge unconstitutionality of laws even if they are not personally affected. Honorable members of the bench, in this case, the applicants have proper standing as they are bringing this case and acting on behalf of affected citizens. Under Article 22(1), it states that every person has the right to institute court proceedings where a right has been infringed, violated, or threatened. Honorable members of the bench, move with me to paragraph 2 of the fact sheet, where it has been, the right to privacy has been violated due to biometrics data collection. In furtherance of my argument, my lord and lady, in paragraph 3 of the fact sheet, the right to equality and non-discrimination under Article 27 of the Constitution of Kenya has been violated as the marginalized groups faced barriers to registration. Moreover, in paragraph 4 of the fact sheet, the right to public participation under Article 10 and 118 of the Constitution of Kenya 2010 have been violated as the law was enacted without public involvement. Now, my lord and lady, a question may occur as to what amounts to adequate public participation. The Supreme Court in British American Tobacco Kenya versus Cabinet Secretary for Health held that public participation must be meaningful and not just a mere formality. My lord and lady.
Counsel, do you know the
My
facts
lord.
of that case?
No, my lord.
Proceed.
Thank you, my lord. In Robert N. Gakuru and others versus Governor of Kiambu case of 2014, the court ruled that public participation requires 1, proper notice, 2, access to relevant information, and an opportunity for citizens to express their views. That, my lord and lady, amounts to adequate public participation.
Counsel, you stated what amounts to participation. Can you kindly show us using the points that you've stated that there was no adequate public participation?
Thank you, my lady. Move with me to paragraph 19 of the fact sheet. Public participation remains a pivotal concern. The appellants argue that the legislative framework governing NIIMS did not involve adequate community consultation. They claim that marginalized groups, including those in arid and semi-arid regions, were excluded from the process due to logistical changes. Furthermore, legal notices published in English and Kiswahili were inaccessible to significant sections of the populace due to linguistic diversity, literacy levels, and geographical isolation. My lady, the government did not sufficiently engage the public before passing Section 9A, which introduced NIIMS. Yes.
Was only done in 2 languages. Was only done in 2 languages. The respondents might come before this court and state that English and Kiswahili are the national languages of the nation. How will you approach that question or that issue?
Thank you, my lord and lady. In that issue, English and Swahili, yes, are the national language of this country. But many marginalized groups, such as the Nubian and Somali communities, were not consulted despite being affected by NIIMS. The respondents may rely on the Supreme Court case of the Finance Act 2023, where the court lowers the bar for public participation. However, honorable members of the bench, these communities already face barriers obtaining national IDs, and the exclusion from public participation made NIIMS discriminatory.
Counsel, I'd like to go to paragraph 22 of the case facts. In paragraph 22 of the case facts, I'd like you to read from where it's written, furthermore. I think it's in the 4th sentence.
Furthermore, the respondents emphasized that the public was notified about the system through extensive media campaigns, stakeholder forums, and parliamentary proceedings, negating allegations of exclusion or insufficient consultation.
Is it enough?
my lady. Thank you, much obliged, my lady. The government held some stakeholder meetings. Public participation must be inclusive, broad-based, and transparent. In Katiba Institute and another versus Attorney General and another case of 2020, the court ruled that selective meetings with a few stakeholders I beg your pardon. The court ruled in Katiba Institute and another versus Attorney General and another. Let me retract my statement. The court ruled that selective meetings with a few stakeholders do not meet constitutional standards. In this case, only a few government agencies were consulted, civil society groups and marginalized communities were excluded, and public awareness was minimal. Proceeding to the second issue, actively involved